Honourable David Parker.
Thank you, Mr Chairman. I want to talk to the supplementary order paper that I have filed and explain why I think it's necessary. Minister, at clause 9 of the bill, the legislation provides that the police may, when an offender returns from overseas, as soon as is reasonably practical, request a returning offender to provide identifying particulars. Identifying particulars are defined as having the meaning set out in section 32(5) of the Policing Act. Section 32(5) has a list of identifying particulars, and I'll read it, and it means any or all of the following. A, the person's biographical details, for example, the person's name, address and date of birth. B, the person's photograph or visual image. C, the impressions of the person's fingerprints, palm prints or footprints. So it all goes to identification of the individual and facts that go to that end, not the convictions or penalties that that person has had overseas. Now, it's understandable why identified particulars are that narrow in New Zealand, because of course the police already know those particulars of their prior convictions and their offences from the New Zealand governmental records that the police have access to. What we don't know in respect of overseas offenders, unless we've been provided that information by an overseas jurisdiction, which we won't always have been provided, is actually the nature of the offence and the sentence that the person has had in that overseas jurisdiction. Maybe that's not a problem with Australia. I'm not sure. We haven't had answers to the question as to whether that there had been gaps in the Australian situation. Well, you should be able to ask the offender what was the offence that they were convicted of and what was the penalty, and they should cooperate with the New Zealand authorities in providing that information. It's even more clear in respect of some other jurisdictions where we don't have those close relationships, but nonetheless this legislation applies to, because this doesn't just apply to Australia, it applies to other overseas jurisdictions, as I'm sure the Minister understands. So my suggestion, Minister, is that you amend that clause, or we in this House amend that clause, to make it clear that in addition to the identifying particulars that are as defined in section 32(5), which I think clearly has to be read a justum generis and really relates to identifying particulars of the offender rather than their record of criminal offending, which is a different thing, the obligation of the person to disclose the details of any overseas conviction and overseas penalty for any such conviction of the returning offender. Without that, I don't understand how you're going to be able to get from the offenders, by right of law, the information that you need or that the authorities need to determine whether the other provisions that kick in under this legislation apply or do not apply, because the tests that you have later in the legislation relate to the seriousness of the offence and the convictions. And I don't see any way that you have got the right to require that information of an overseas jurisdiction. You might have cooperative relationships which normally provide that information, but we in New Zealand do not have jurisdiction to require Russia or India or China to provide that information to us. What we could through this legislation is require the returning offender to provide that detail of information, or at least cooperate with you in a way that enables you to get that information. And if they don't, well, they suffer the consequences of not getting the liberty that they probably want. So hopefully this matter is not a matter that you're going to have to take an instant decision on before 10 o'clock. If you are, then you're going to have to, with respect, take a decision in the chair as to whether you think that my analysis of that is correct. Sorry, Mr. Chairman, the Minister will have to take a decision in the chair as to whether there is a gap in the legislation, because my understanding, one of the things that the government wants to achieve in respect of this is gathering the information that is needed at the border to assess whether these other flow-on consequences should apply to the person. And if you haven't got the information as to what is the nature of the conviction and what is the nature of the penalty, I don't see how that can be done properly. This actually raises the question, the other question as to whether the review, Mr. Chairman,
David Parker.
as to whether the review provision at 37 is adequate. I, for reasons that I've said previously, but I haven't had a response from the Minister while I've been in the House. I haven't been in the House the whole time, so the Minister may have given an explanation previously. But this is another instance of why the review after 2 years by Justice and Electoral Committee is no substitute for the process which the Labor Party opposition was suggesting. And I like to think that I'm approach these matters from a point of principle. I agree urgency is necessary. We're critical of why that it is necessary, but we don't have to agree on that to agree that we should be doing this in the best possible way, given that we are in urgency. And I still think it would be desirable to have a companion bill going to Select Committee now with a sunset date in this clause, in this legislation that was a reasonable period out. We had suggested a year, it could be 2 years. You could at the same time have a bill in front of the Select Committee that was hearing submissions upon that would have turned up issues such as the one that I've identified, some of them such as Dennis O'Rourke and other members have identified, which could be resolved at the Select Committee process in the year, so that the legislation that went forward from that period forward after the initial legislation lapsed could take into account all of those issues. Mr. Speaker, Mr. Chairman, I think that's probably. Oh no, the one other issue that I still await a response to is arising from clause 28(2), or another issue, not the only other issue, which appears to oust the jurisdiction of the court to consider the validity of a decision made by the Commissioner of Police which triggered the imposition of standard release conditions. And it appears to me that 28(2) is an attempt to oust the jurisdiction of the court. I think it would be helpful to the courts if the Minister has a contrary view that be expressed. I'm not sure what the intention of 28(2) is, but it appears pretty plain on its wording to say that a court must not discharge a standard release condition with effect from a date that is less than 6 months after the date of the service of the determination notice. And I'm not clear whether that's intended to oust the jurisdiction of someone to go to court to say that the Commissioner of Police was ultra vires the preconditions to the issue of sorry, I've forgotten the name, of the notice that a Commissioner of the Police has jurisdiction to issue under the determination notice that the Commissioner of Police issues. I would request that the Minister particularly consider this issue as to whether you're going to get all the information you need from an offender once they arrive back on the border. Perhaps that could be considered overnight.